On the procedural front, there is a specific pathway that any civil case must follow upon institution. Procedure is, of course, an important aspect of dispensation of justice. It must be noted herein that the registry of a court has a right to dismiss the suit, especially in case of brazen irregularities. Here's a very brief overview of what the standard process usually looks like. The first step is, of course, the filing of a plaint or a suit. A plaint lays out the grievance of the petitioners. The person filing it is usually called the plaintiff, and the person who defends his or her stand against the plaint is the defendant in the case. The plaint specifies the name of the court, the nature of the complaint, and the names and addresses of the parties to the suit. It also contains a verification on the plaintiff stating that the contents of the plaint are true and correct to the best of their knowledge. A Vakalatnama, on the other hand, is a written document through which the party filing authorizes an advocate or a lawyer to appear in court on their behalf. However, if the person or the party appears in person, of course, there is no need to file a Vakalatnama. Filing of the plaint is done before the Chief Ministerial Officer after paying requisite court fees and process fees. The amount is usually dependent on the type or the court as well as the type of the document. On the first day of hearing, if the court thinks that there is merit in the case, it issues notice to the opposite party to defend their case and fixes a date. When the notice is issued, the plaintiff is required to file requisite fee amount in relation to the documentation. He or she also has to file 2 copies of the plaint for each defendant. Of the 2 copies, one is sent by registered post or courier, and the other is sent through ordinary post. Such filing usually has to be done within 7 days from the date or date of issue of notice. Once notice is issued to the respondent, he or she is required to appear on the date specified in the order. Before such date, the respondent is required to record his or her written statement. That is a record of his contention or claims against the other party within 30 days from the date of issue of notice. It is extendable up to 90 days or such time as is granted by the court. The written statement also contains a verification from the defendant this time, stating that the contents of the written statement are true and correct to the best of the defendant's knowledge. In part 2, we shall consider what happens once the written statement is filed by the defendant.